Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit about the I-130. Now, anyone who has done a family-based petition knows that the first part is the I-130. So whether you're petitioning your spouse, your son, your daughter, your sister or brother, your parent, depending on the relationship, it has to begin with an I-130. So all in all, the I-130 begins the process. Now, I have received so many questions and incorrect conclusions as to what the I-130 is over the last few months. I thought I'd make a video on it and explain it in some detail. One of the biggest misconceptions is that people think that they filed the I-130 and it's been approved and therefore they're home free and the person they petitioned is going to get the green card, no problem. That's not the case. The I-130, let's just talk about a spouse petition to make it easy here. The I-130 will determine and show that you two are married, that you are a U.S. citizen or lawful permanent resident, and that your spouse is who he or she says they are. The I-130 does not test for inadmissibility. It does not test for eligibility of adjustment of status or consulate processing. It does not look into the criminal history of the person. It does not look into any prior deportation orders. It doesn't look into any of that. I mean, to exaggerate, a person could have committed 22 different crimes, have 14 deportations and 22 illegal reentries, and still get an I-130 approved. Okay, so given that, I hope I'm making it clear. The I-130 just tests and shows the eligibility of the relationship. Okay, now after that, after the I-130, then it's time to determine whether or not the person's admissible or inadmissible, whether they need waivers, whether they can adjust, whether they have to consulate process, whether they have to stay in or out of the country, whether or not there's something that's barring them from adjustment. So for example, let's say that a person committed a crime, of selling cocaine, okay, and they pled guilty and they got deported. So now the question is, and let's say, 5 years later they got married and they're madly in love and they have 13 kids. Um, the I-130 can be done. That's no problem. Okay. And this is where I run into a lot of people who think they're home free, is they say, well, I filed the I-130 and I got the approval, so therefore they must be able to let me into the US. So in this particular case that I just gave the example of the selling the drugs and the deportation, that particular person can certainly file and get approved in I-130, but that person's permanently inadmissible from the United States or to the United States because that person's an aggravated felon under the immigration laws, and there's no waiver, minus some few exceptions, for that. So even with an approved I-130, marriage to a U.S. citizen, that person won't be able to come into the United States. So the problem of the crime needs to be taken care of, which it can, in order to open the doors and allow them to proceed. Now, likewise, let's say that somebody entered illegally into the United States several times, and now they married a U.S. citizen and they filed the I-130. They got the I-130 approved, and again, they think that they will be able to adjust status without a problem. Well, first of all, again, the I-130 can be approved if, assuming it's a bona fide marriage, but the adjustment cannot be done because we have multiple illegal reentries, and most likely there's an expedited removal order, and that person is permanently inadmissible and can't even apply for a waiver of permanent inadmissibility for 10 years outside the United States. So that that's another issue. So when a lot of times when people will go to either attorneys who are not as familiar with immigration law, or notarios as they're called, and they'll present to them that they'll file the I-130 and get it approved and they're home free. That is by no means the case. So when I do an initial consultation, of course, in addition to seeing if the marriage is bona fide, if we're talking about a marriage petition, I do have to question about whether or not there's any inadmissibility issues, deportation issues, criminal history, and so forth. Now, where does the I-130 fall where it won't be approved depending on criminal history? And there's really one major area of that, and that's when the U.S. citizen or lawful permanent resident has committed a crime, some type of crime of sexual abuse of a minor. Okay, this was derived from Megan's Law. So the, this is called the Walsh waiver. Okay, and an I-130 will not be approved if the petitioner has such a crime. Okay, that's where the I-130 won't get approved, unless you have an approved Walsh waiver. But other than that, it's as I had stated, and it's just the first step. A lot more work to do after you get an approved I-130. So if you like the video, click like, subscribe, and more on the coming weeks. Thank you.